The subcommittee will come to order. Without objection, the chair is authorized to declare recesses of the subcommittee at any time. Welcome to this morning's hearing on counterfeits and cluttering, emerging threats to the integrity of the trademark system and the impact on American consumers and businesses. I will now recognize myself for an opening statement. Good morning and welcome to the House Judiciary Subcommittee on Courts, Intellectual Property, and the Internet's hearing on counterfeits and cluttering, emerging threats to the integrity of the trademark system and the impact on American consumers and businesses. Today's hearing will elicit critical information regarding the state of trademark protection in the United States. Trademarks are the foundation of a successful commercial marketplace. Trademarks ensure that consumers know whose product they are buying. In turn, the trademark system rewards companies that invest in quality, which consumers then associate with that company. This adds up to an intellectual property system that brings tremendous value to our economy. According to Forbes, the 100 most valuable brands are worth a cumulative $2.33 trillion today. But it is not just large corporations that benefit from trademark protection. About 1/3 of trademark applicants are small businesses or individuals. Threats to the trademark system therefore impact businesses of all sizes as well as consumers. Today's hearing will examine 3 emerging challenges for the trademark system. First, we will examine the problem that we are running out of new trademarks, or at least good marketable ones. This problem is being exacerbated by the number of marks on the register that are not being used, a key legal requirement of the United States. These unused marks, or clutter, may be standing in the way of others who might want to use some version of that same word or phrase for their own trademark. This problem is being made worse by a recent spike in fraudulent trademark applications, many of which originate in China. Second, we will look at some courts' reluctance to award injunctive relief to trademark owners who win an infringement lawsuit. This is often the key remedy for trademark owners because it makes sure that a trademark too close to their own is off the market. Moreover, allowing similar marks to stay on the market could ultimately lead to more consumer confusion, the exact opposite of what the trademark system is designed to produce. Third, we will examine the misuse of trademarks and counterfeit goods sold by third parties through online platforms. Instead of hawking fake goods on the street, counterfeiters are now becoming sellers on online marketplaces where the barrier to entry is low and the mechanisms for misleading consumers are plenty. Consumers might not be aware that they are buying fakes, much less ones that could pose safety risks. With e-commerce sales expected to reach more than $4 trillion globally in 2020, this is not a problem that Congress can ignore. Last month, I held a roundtable with brand owners and online platforms so that we could begin to explore these challenges. I'm pleased that this discussion will continue today. While these threats to the trademark system are a problem for all stakeholders, I'm particularly concerned about the impact of these issues on small businesses. An inaccurate and overcrowded trademark register will prevent small businesses from easily registering their marks and getting the benefits of federal registration. The prevalence of online counterfeiting means a successful small business operating online runs the risk of having its products copied and sold, diverting sales. While online platforms offer some tools for companies to report and remove infringing listings, this often becomes a game of whack-a-mole, where as soon as you remove one counterfeit seller, another appears. Small businesses have the least amount of resources to engage in this constant monitoring. I look forward to hearing from our distinguished witnesses on this important day on these important topics. On our first panel, I'm pleased to welcome the Commissioner of Trademarks from the Patent and Trademark Office. I know that the office takes these issues seriously, and I look forward to hearing more about its work on these topics. Our second panel has witnesses from industry, the legal community, and academia for the topic of online counterfeits. While no larger online marketplaces were able to physically attend today's hearing as witnesses, a few have submitted statements for the record. I'm encouraged and hope that they will continue to engage with the subcommittee going forward. We all have a stake in making sure that this vibrant sector of our economy does not have its reputation tarnished by being overrun by counterfeit goods. To all of our distinguished witnesses, thank you for coming here today, and I look forward to your testimony. And it is now my pleasure to recognize the ranking member of the subcommittee, the gentle lady from Alabama, Congresswoman Roby, for her opening statement.
Thank you, Chairman Johnson, and I want to thank each of our witnesses for taking the time to share their expertise with us today. I think it's amazing when we decide to go shopping for a particular product. All we have to do is search for it on our computer or our phone, and with a few clicks, we can buy it and have it delivered at our door. We can do all this from the comfort of our home, on a beach, traveling in a car, or wherever we are. For us, on an airplane. Online shopping has revolutionized the shopping experience for all consumers. Worldwide e-commerce sales are expected to reach over $4 trillion by 2020. And e-commerce retail sales are expected to reach nearly 15% of overall global retail spending in 2020. Amazon, eBay, Apple, Walmart, Home Depot, and countless others are making shopping almost effortless and show that the popularity and convenience of online retail is continuing to increase. But with all of that convenience comes risk and responsibility. As the GAO detailed in its 2018 report on counterfeits, along with an increase in opportunities for consumers to find products they want, online marketplaces are also providing opportunities for counterfeiters to reach a much broader customer base. The report indicates that the volume, value, and variety of counterfeit goods entering the United States increases each year. The GAO reports that counterfeits exploit third-party online marketplaces to gain an appearance of legitimacy by posting pictures of authentic goods on websites and posting fake reviews of their products, all to trick consumers into buying their knockoffs. In addition to inflicting economic harm, counterfeit goods may pose a risk to health and safety of consumers. 20 of the 47 phone chargers purchased by GAO from third-party sellers on popular e-commerce websites were counterfeit. Some were so defective that they posed a significant risk of catching fire or even electrocuting a consumer. Customs and Border Protection has seized counterfeit versions of personal care products such as contact lenses, perfume, hair removal devices, hair curlers, and skin cleansing devices. Any of these products, should they contain bacteria or dangerous chemicals, could cause significant damage to a consumer's skin or eyes. On a personal note, I've used online marketplaces to purchase cosmetic products, and as I've learned more and more about the risks posed by counterfeit cosmetics in connection with investigating this issue, I'm having to reconsider my own purchasing decisions. At our Counterfeits Roundtable we held in June, which I thought was great, we heard what happened to a few consumers who bought products that posed a significant health or safety risk. A contact lens contaminated with bacteria injured one person. A counterfeit airbag killed a driver. A faulty toy with magnets that caused a child to undergo surgery. We cannot let counterfeit products, which undergo none of the rigorous safety testing often required here in the U.S., to be sold to unwitting U.S. consumers. I look forward to hearing from our witnesses whether marketplaces are taking all of the steps that they should to protect consumers from counterfeits, or if there are additional steps they must take to protect us all. I want to know if Congress needs to act to mandate that marketplaces establish certain practices designed to protect consumers from counterfeits, or if there are any other recommendations for Congress to take on combating this issue. Another issue that we are addressing today is a substantial increase in trademark filings. I have read reports that subsidies issued by the Chinese government to promote the registration of marks in the United States has directly led to a dramatic increase in the number of U.S. trademark applications. Many of these trademarks have been registered by the USPTO, and even though these applicants misrepresented that the mark was actually used on products for sale in the U.S. Today, we need to hear from all of our witnesses how to best deal with these fraudulent trademark registrations, whether the USPTO is doing all that it can to prevent these filings from being registered, what, if any, new authority the USPTO needs to remove fraudulently obtained registrations. Finally, I know that the courts are split on whether trademark owners who prove a likelihood of confusion should be entitled to a presumption of irreparable harm, making it much easier to obtain an injunction. In trademark cases, injunctions are the primary source of relief. That is because measuring the dollar amount to attach to a trademark infringement, the harm to reputation, can be very difficult to approximate. I want to hear from the witnesses whether Congress needs to resolve this circuit split. As the ranking member of this subcommittee and the co-chair of the Congressional Trademark Caucus, I want to make sure our trademark system is working effectively. I look forward to delving into these very important issues today, and I want to again thank all of our witnesses for being here, and I thank you, Chairman Johnson, and I yield back.
Thank you, Representative Roby. I ask unanimous consent that the statement of the Honorable Gerald Nadler, today's the chair of the Committee on Judiciary, that his statement be introduced for the record without objection. And without objection, so ordered. I will now introduce the witness, Mary Bonnie Dennison is the Commissioner for Trademarks at the United States Patent Office, United States Patent and Trademark Office, the USPTO. In her role, Commissioner Dennison oversees all aspects of the Trademarks Organization, including policy, operations, and budget relating to trademark examination, registration, and maintenance. Commissioner Dennison joined the USPTO in 2011 as Deputy Commissioner for Trademark Operations, where she was responsible for the USPTO's trademark application, legal examination, and registration processes. Before joining the USPTO, Commissioner Dennison practiced law in the area of trademark prosecution and litigation as a founding partner of Manelli, Dennison, and Selter in Washington, D.C. She also served as a member of the Board of Directors of the International Trademark Association and as a member of USPTO's Trademark Public Advisory Committee. Commissioner Dennison holds degrees from Duke University and the University of North Carolina School of Law, and we welcome Commissioner Dennison and thank her for participating in today's hearing. I also understand that Ms. Dennison's term as commissioner ends later this year. As this may be her last appearance before the subcommittee, I wish to thank Commissioner Dennison for her productive partnership with us and for her 9 years of public service. We are grateful that she chose to bring her extensive trademark expertise to the federal government, from which we have all benefited. I thank you, and before proceeding with testimony, I hereby remind all witnesses that all of your testimony, written and oral, made to the subcommittee in connection with this hearing are subject to penalties of perjury pursuant to 18 U.S.C. Section 1001, which may result in the imposition of a fine or imprisonment of up to 5 years or both should the individual be found guilty. Please note that your written statement will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals that your 5 minutes have expired. Commissioner Dennison, you may begin.
Chairman Johnson, Ranking Member Roby, members of the subcommittee, good morning, and thank you for holding this hearing to highlight the problem of inaccurate trademark filings. The USPTO's aggressive efforts to address this problem and the USPTO's efforts to combat counterfeits. I've worked on these issues for a number of years, and the USPTO welcomes the subcommittee's attention to these important issues. The U.S. trademark system is the global gold standard and is a fundamental component of our economy and a driver of economic growth and job creation. The USPTO is committed to maintaining the integrity of the trademark system and all the benefits for businesses, consumers, and the U.S. economy that an accurate trademark register brings. Generally, a trademark is eligible for registration if it is used in commerce. Apart from limited exceptions, for a mark to be federally registered, the applicant must provide an example called a specimen. That specimen must show how their mark is actually being used in commerce in connection with the goods or services in the application. In addition, to maintain a registration, the registration owner periodically has to file a sworn declaration listing all of the goods and services in the registration for which the mark continues to be in use in commerce, and they must also include a specimen of use. Unfortunately, in recent years, the USPTO has seen a significant increase in the number of applicants who are not fulfilling their legal and ethical obligations to file accurately and in good faith. Specifically, the USPTO has increasingly been receiving trademark filings involving false use claims and fake or digitally altered specimens that purport to, but do not actually show, use of the mark in commerce as required by law. While some of these problematic filings are domestic, a significant and increasing number come from overseas, primarily from China. Often, those applicants are represented by unauthorized Chinese individuals who evade USPTO sanctions. Because there is no one silver bullet to solve these issues, we've taken a multi-pronged approach to combat this problem, including, number one, requiring foreign domiciled applicants to be represented by U.S. counsel. The USPTO will have a U.S. lawyer who can be held accountable for improper filings, even when those applications are filed from overseas. Number two, auditing post-registration maintenance filings to ensure that the mark is being used in commerce in connection with all of the goods and services in the registration. Number three, updating examination guidance and training on questionable specimens of use that instructs examiners to issue refusals when they discover fake or suspicious specimens of use, rather than just requesting additional specimens as was the past practice. And four, creating a special task force to develop and implement additional policies, procedures, and technology solutions. And we plan to do more, including building an electronic database of specimens to help examiners locate specimens that use virtually identical pictures for different trademarks from different applicants. Number two, revising the requirements for specimens. Number three, proposing additional incentives for trademark owners to voluntarily update their registrations when they are no longer using their marks on particular goods and services. And fourth, providing more education to applicants and their lawyers on what use in commerce is. As you can see, the USPTO is aggressively working to address these problems. To my left, and in front of each of you in your packages, are examples of specimens in 5 different applications for different marks that we received, real and fake. As you can see, the digitally altered images are quite sophisticated. Through our updated, specialized examination training, our examiners were able to reject the fake specimens in these examples. The USPTO is taking every step within the current statutes to fashion solutions to the problem of false claims of use in commerce. We are doing all we can to ensure that the U.S. trademark system remains the world gold standard. My written testimony also details USPTO's efforts to combat domestic and international counterfeiting. The USPTO is actively involved in the policy development process within the administration related to combating online counterfeiting, including the report required by President Trump's memorandum on combating trafficking. It also continues its strategy to provide technical advice and capacity building to foreign governments and to provide public outreach and education, including through the IP Attaché program and the China team. Thank you for this opportunity to testify about these important matters. I look forward to answering your questions.
Thank you, Commissioner Dennison. We will now proceed under the 5-minute rule with questions. I will begin by recognizing myself for 5 minutes. Commissioner Dennison, I am concerned about the rise of fraudulent trademark applications. What happens if a trademark application with a fake specimen has already gone through registration, and can the USPTO pull that registration back on its own if it becomes aware of the problem?
Thank you, Chairman Johnson, for that question. We do our best to register high-quality trademarks. We issued about 270,000 registrations in fiscal year 2018. In the event that we discover a mistake that we made in examination in a timely fashion, we will correct the mistake. However, for the most part, the statute requires that third parties petition to cancel problematic registrations at the Trademark Trial and Appeal Board.
When you say you correct a mistake, what do you mean?
For example, if we find something before the registration has issued, then we are able to stop it from issuing.
But after it's issued, there's basically no statutory authority for you to do anything.
We largely rely on third parties' ability to cancel registrations at the TTAB, the Trademark Trial and Appeal Board.
Thank you. I understand that it can take a year or more for a trademark application to be examined, and that an existing application will block a later filed application for a similar mark. Part of the reason it can take a year is because of the 6-month response period when the PTO issues a refusal. Does the PTO have any flexibility with that 6-month response period?
Thank you for the question. The 6 months for response to an office action is provided for in the statute, so we do not have flexibility to change that.
Do you have flexibility to lessen the 6-month response period?
No, Chairman Johnson, we do not have flexibility to change that.
All right.
That is a statutory mandate.
Thank you. Commissioner Dennison, what are the consequences of lying in a trademark application or registration? And can applicants be sanctioned for lying to the PTO?
A registration is subject to cancellation if it was obtained by false material statements. And the registrant could be subject to civil penalties. They do file declarations under penalty of perjury. If there was an attorney who was involved in the case, they could be, and they made material false statements, they could be subject to an investigation by the U.S. Patent and Trademark Office's Office of Enrollment and Discipline, and they could face sanctions such as exclusion before from practicing before the USPTO.
So what about if the registration has been issued and then the PTO learns thereafter that the registrant has lied? Does the PTO have any authority to take away the registration at that point?
At that point, we have to rely on third parties to seek a cancellation at the Trademark Trial and Appeal Board.
Thank you. That concludes my questions for this witness. I will now turn to the ranking member for her questions.
Thank you, Chairman. Commissioner Dennison, thank you again for being here. Does the PTO know how many applications that it filed in the wave of filings from China that it granted, but that now has determined that they should not have?
Thank you for that question. Unfortunately, we have no way of tracking what registrations may have been issued with fake specimens. We received more than 400,000 applications a year, with about 60,000 of those coming in from China. Of those, about half of the Chinese application received either a refusal to register or an additional request for information. In fiscal year 17, we issued about 20,000 registrations to Chinese applicants, and in fiscal year 18, we issued about 38,000 registrations. Hopefully, most of those were for legitimate businesses.
So the PTO stated that from 2013 to 2017, applications from China increased by 1,000%.
I believe it was actually 1,200%.
Okay, so while this increase in numbers is not in and of itself proof of fraudulent filings, did this not set off any red flags or alarm bells within the PTO?
Absolutely, it did, and we've been taking quite a few steps to address the issues.
Okay, so now that the PTO has registered an unknown number of trademarks based on, per your own testimony just now, an unknown number of trademarks potentially based on fraudulent evidence of use, many from China, what can the PTO do to remove those fraudulently obtained trademarks?
Well, as I mentioned, there have been thousands of registrations to Chinese applicants, and many of those are for legitimate businesses. So we have to balance the large amount of work that would be required to review every single registration issued to a Chinese applicant and consider that even if we were to find certain registrations should not have been issued, we would have to rely on a third party to seek cancellation at the Trademark Trial and Appeal Board.
So it's my understanding, and this is just putting an exclamation point on it, that the application fees for a large number of fraudulent trademarks were paid for by only 3 credit cards. So is the PTO not able to review all of the trademarks paid for by those credit cards, since it seems that there's a high likelihood that they're fraudulent?
Yes, the 3 credit cards did set off alarm bells at the PTO, and we are taking this very seriously. We have formed a special task force, and their job is to look at the whole problem, and we have IT people working on it, we have lawyers working on it in a team, and their goal is to identify problems as they come in and to propose solutions for us. I get a weekly report.
Is there a time frame under which this task force is operating?
It will be ongoing.
Okay, so what I would just ask, Mr. Chairman, is that we get pretty regular updates about the progress of that task force. I think that would be helpful for us in light of our line of questioning here this morning. But my next question is, does the PTO need additional statutory authority to remove fraudulent trademarks it mistakenly registered?
Thank you for that question. We administer the laws that you pass, and we are happy to provide technical assistance to you, and we have been doing that on a variety of topics.
So we're just asking if there's roadblocks based on the chairman's questions, if there are things that are inhibiting you from doing so, that you do offer those recommendations to us so that we could make changes if necessary, so that we could be helpful in that. Several of the examples that I've seen for incorrectly registered trademarks have clearly doctored photos and very obvious indications that the application is fraudulent. So what is the PTA doing to ensure that examiners are properly trained and have the resources to avoid registering these trademarks going forward?
So we have been doing specialized training for the examining corps. They're faced with a very difficult situation. As you can see from these examples here, it's hard to tell. One will come in and they will have to look at it very carefully, and they're on production, so they don't have 3 hours to spend on this. And so I think they're doing a great job doing this. And so we have issued an examination guide. It's number 3-19, and it gives them a list of things that they should look for. For example, is there pixelization around the wording? Does the mark appear to float over the product? That kind of thing. We have a long list of things that they are now taking into account. Okay. And in the past, we had asked them if they saw something suspicious to ask for more information. Now we're saying if you see something suspicious, issue a refusal And then you can also ask for more information, but we're being more aggressive now about this.
Good. So my time has expired, but again, Mr. Chairman, I would just ask that in light of the task force that you mentioned, that this committee be given somewhat regular follow-up on the progress of that task force. I think it's very important for us to be aware of any progress, and then look forward to your recommendations of how Congress can be helpful. So thank you. I apologize for going over. I yield back.
Thank you, Representative. Next, we will have questionings from Mr. Ted Deutsch, the gentleman from Florida.
Thank you, Chairman Johnson, for holding this hearing, and thanks, Commissioner Dennison, for taking time to be here with us as co-chair of the Congressional Trademark Caucus with my friend and judiciary colleague, Martha Roby. We know that trademarks play a critical role in enhancing innovation and helping our economy grow and thrive, and that we've got to be vigilant in protecting intellectual property to ensure the health of our innovation system. I want to go back to where Congresswoman Roby left off, and the combination of the task force that you've created and the training, you identify this specimen rule. Can you tell us either the role that technology is playing in this task force, the attention paid to it, who's been brought in with the technological expertise? And the reason I ask is because I think it certainly sounds worthwhile to have some guidance that talks about floating marks and pixelization and how to identify them, but it certainly seems as if this is the kind of thing that we ought to be able to use technology in a very serious and advanced way to help identify. Can you just speak to that, please?
Yes, thank you for that question. In fact, we have been piloting some software that we hoped we could give to examiners so that they could run a specimen through it to see if it worked or not. What we have found is that you kind of need to be a computer expert to interpret the results. So we are continuing to work with the software company. And just yesterday, I saw a chart showing that they could rank it as to how much it had been altered and that kind of thing. So right now, we don't have a technology solution that is usable on a widespread basis by our examining corps, but we are continuing to work on that solution. We are also able currently to use reverse image searching. So if the examiner sees an image, they can use a reverse image tool and see if there is something highly similar on the internet.
Okay, I appreciate that.
Could I raise one other thing?
Sure, of course.
So we have a database of trademarks. We have never had a database of specimens of use. And so we are also working towards building a database of specimens. So that would mean that if we had that, then we could see that the scarves on the left in the poster, that actually looks like a good specimen, but it's not a good specimen because it came in with 10 different files from 10 different applicants for 10 different marks. And the database of specimens will help us to find that.
Have you, at this point in the work that's been done, have you been able to detect any commonalities in the suspicious specimen applications?
What do you mean by commonalities? You mean
many
of them are coming from Shenzhen.
So in this case, you've identified the same image used in multiple applications. Are there other commonalities that have come up?
Yes.
Perhaps geographical, perhaps in the image itself.
Okay, so if you see the bottle on the lower right, that is a computer-generated image, again, not showing the mark in use in commerce. So that's another way that they are doing things. If you look at the Instamarket photograph on the right, that is one that was, I believe we have a specimen protest pilot where people can send in images to us, and so that was picked up by a third party. They sent it to us, and it turns out that it was a Walmart store, and they had taken Walmart off of it and put Instamarket up there. So those are three different examples.
Under your existing authority, Section 9043.3, examiners have the authority to issue refusals rather than inquiries. where an item or where a specimen doesn't appear to show actual use in commerce in the U.S. market. Have you considered reviewing pending or approved registrations to confirm that they're in use in the U.S. as a method to declutter the register?
We have instructed examining attorneys to refuse now if the specimen is suspicious. Due to the volume of work, I would say we have not discussed going through every single one of the, because we get over 400,000 applications a year, going through every single one to do a second check on it. We have to trust the examiners to get it right. There are quality checks done, however.
I'm hopeful that as you go forward, the decluttering the existing granted trademarks should be a priority as well, because it takes so long in order for an actor to file a challenge to a pending application. I hope this is a focus of your efforts as well, and I thank you for being here.
Thank you.
Thank you, Mr. Chairman. I appreciate that. Before I get started on my statement, basically it's just going to be a statement at this because this is something that I'm glad the chairman and the ranking member have such passion in this, and this is something we need to be talking about. But I'm also going to talk about who's not here. And I do this not in any other way except we need to have everybody to the table. So I know that Amazon, eBay, and Walmart are listening. They are friends. We know each other, but we cannot hide from this discussion. And I need them to be a part of the discussions at the table. This is not new for this subcommittee, it's not new for this committee, and it's definitely not new for anybody who knows me, that the way you solve problems is not by avoidance, but by actually taking the issues on, and I want to help that. It'll be something that we can do, but we cannot discuss issues around issues when we don't have a lot of times the players here. And I'm so glad the PTO office is always here. It's always good to see you guys as being a part. But those are the kind of things that we need to talk about. One of the things I'm concerned about many times is when we avoid things, then we have misunderstandings. We could clear those up early in the process, and we could also remember that while we're doing it, it's just not only for these companies that I named and not out of shame or anything else, but why shouldn't you be here? Because we're trying to make this better for you and for the end result and for the customer who is at the bottom line, our constituents, and we need to be a part of that as well. So with that, I appreciate the opportunity. And what we have to understand is the rampant sale of counterfeits online is not just a threat to U.S. jobs and innovation. It also poses a threat to consumers. Through their third-party marketplaces, platforms are selling contact lenses contaminated with bacteria that catches fire, cheaply made toys that allow children to swallow magnets and force them to undergo surgery, and even airbags that kill a driver. The list of counterfeit products is being sold online is endless, so just imagine how often we expose ourselves and our loved ones to harm when we are tricked into buying counterfeits online. Online marketplaces have the choice to aggressively protect consumers from counterfeits, show respectful for other property rights. But brand owners argue some of making merely a cosmetic effort. Certainly marketplaces could do more to stop their sites from being used to sell counterfeits, which is why we would need to hear from them. We recently held a roundtable to hear from brand owners and platforms on this issue. Which platform has demonstrated it is truly committed to stopping the sale of counterfeit and by protecting consumers? By most account, it's Alibaba. At the roundtable, we learned that Alibaba's anti-counterfeiting policies and programs are significantly more effective than their U.S. counterparts. They are working very closely with all complaining brand owners and are using cutting-edge technology to scan for and detect counterfeits. I find it shocking that U.S. platforms are so far behind. Marketplaces must aggressively protect U.S. customers and IP rights holders from sellers who seek to trick consumers into buying counterfeits. Marketplaces must have effective policies and practices to detect, block, and the sale of counterfeits automatically and are immediately responsive to complaints by consumers and brands. Quickly remove counterfeiters from their sites and detect and prohibit confirmed counterfeiters from returning under another name. The marketplace must apply these anti-counterfeiting policies and practices with equal rigor to protect all brands, particularly our small businesses, and not reserve their best protections for a few companies that bring huge profits to the marketplace. Platforms must do a better job of vetting sellers and sharing information with brands, consumers, and law enforcement so these thieves can be brought before U.S. courts. Marketplace should not allow sellers to trick consumers into buying a counterfeit by using a product's image without the brand owner's consent. Marketplaces should not promote counterfeit sellers' products by highlighting the products of sellers offering the same item at a counterfeit price. These solutions are well within the grasp of our large online marketplaces and practices they should have already implemented on their own. I hope the witnesses will wish that we had the witnesses here to also talk about this, which we don't, and I say that just from an encouraging way so that we can find a way forward. And I appreciate the work that the PTO office has done on this. I will continue to encourage what you are doing, because we have to find an answer here. At the end of the day, this is not about, and from my perspective and for those who have worked with me, this is not about labeling bad and good. This is about labeling that we have a problem, let's fix it. We have issues that need to be discussed, let's discuss them. It is not about avoidance, and when we have avoidance, then we have misunderstanding. Misunderstanding leads to bad law. Bad law means that I have to sit through hearings after hearings after hearings on discerning why we have bad law. So let's get it right the first time. Let's have it right the first time. Let's have honest conversation, and let's do this the right way to begin with. I thank the chairman. I thank the ranking member of the subcommittee who have done outstanding work together on this, and I appreciate the witnesses that are going to be showing examples of that today, and of course, always the friends at the PTO office. And with that, I yield back.
Thank you, sir. With that, we will now hear from the gentleman, Mr. Stanton, for 5 minutes.
Thank you very much, Chairman, and I agree with the ranking member, Collins, a lot of things he just said, and about the need to get the right players here and to get this right. Obviously, today's testimony is mostly about the trademark system, closely related to counterfeits online, so those are very appropriate comments. Look, I want to thank the witness for being here today, Chairwoman Commissioner Dennison. It's essential for big business, small business, all business to be able to successfully apply and receive appropriate trademarks. There are important mechanisms by which companies can identify themselves to consumers and within the marketplace. And of course, consumers can build trust with the business in part by way of appropriate trademarks. When that trust is broken by counterfeit or fraudulent trademarks, a great deal of harm can be done, not only to the business, but to the consumer marketplace as well. It's important that Congress address these issues head on and that we work with stakeholders to make appropriate changes to ensure that our American trademark system is the best in the world and is as effective as possible. Commissioner, the fiscal year 2018 USPTO Performance and Accounting Report indicated that trademark quality would be a top concern for the department. What is the goal for trademarks in fiscal year 2019, and will you provide updates to the committee on the progress to address this important issue?
Thank you for that question. Yes, we will be happy to provide updates to the committee, and we are highly focused on quality. As I mentioned earlier, we have had advanced examiner training on specimen detection, and we had that in June. We'd had it previously, and we had it again in June, and we are bringing all the examiners into the office in August, and we will have training again on specimens at that point. In addition, we have issued the examination guide I referenced earlier, Examination Guide 3-19, which has now been issued to the public, and you can see a list of things that we are carefully looking for, in addition to looking for IT that can help us enhance our quality. We're always looking to improve.
You mentioned IT, and your recent report indicated that you're trying to transform USPTO with next generation technology and services. Talk about those technology and services. Do they allow you to keep track of the bad actors that continue to submit fraudulent trademark applications?
Yes, we know who the bad guys are. We don't really have jurisdiction over many of them, but yes, we generally know who they are. We do have a sort of a whack-a-mole problem. I've issued exclusion orders, and people change their names.
When a trademark is found to be fraudulent, what's the remedy? What's the system for a remedy of that currently?
Well, if there is a specimen that is submitted, the examiner reviews it. If they think the specimen is suspicious, they will refuse registration.
And what about fines? Is there fines imposed upon the fraudulent actor?
We do not have the ability to impose fines.
Is that something you'd like to have?
If Congress would like to give it to us, we'd be happy to talk to you about it.
Have you had a chance to calculate the effect of fraudulent trademarks issued from actors in other countries in relation to lost revenue for businesses in the United States?
No, I would say I do not have that information. Perhaps someone in my office would. I would have to get back to you on that.
And then talk to us about the process of third-party reporters, companies that see fraudulent trademarks or doctored specimen? What is the process for them to report that to you?
We have something that we started more than a year ago, I think about a year and a half ago, called a specimen protest pilot. So they can send, say they see the Walmart, the Instamarket photo up there. That was something that came in through the specimen protest pilot because somebody saw that, knew it was a Walmart building that had been digitally altered, and so they sent that into our mailbox. In addition, if they want to go more formal, they could file a letter of protest. And that's during the application process. If the if it's already been registered, then they could seek cancellation. Oh, and there's one more option. If it has been published but not yet registered, they could seek to oppose it at the Trademark Trial and Appeal Board.
Thank you for your testimony. Yield back.
Thank you. We will now recognize Representative Biggs for 5 minutes.
Thank you, Mr. Chairman. Commissioner, thank you for being here. I'm just going to, I want to get to a very rudimentary level because that's where I operate most of my life. So I was looking at your testimony, summarizing it. We're talking about China leads in the number of pro se filings at 80%. Why is that?
I can't give you a definite answer. I suspect it's because of the filing factories that are coming in. I'm not sure how familiar you are with the situation, but we believe that there are filing factories that have been set up to obtain the subsidies that are being offered by certain regional and local governments in China. And those filing factories maybe Chinese lawyers, maybe Chinese paralegals, may just be people off the street. I don't know who they are.
Okay, but I wanted to get into, thank you for getting there because that's where I wanted to go for part of this anyway. The filing factories, they are supported by regional and local government in China with subsidies, is that correct?
The filing factories per se are not. The filing factories, the regional subsidies or local subsidies that come from a number of different places in China, not just Shenzhen, they offer these subsidies and they're quite high. And so I suspect that the filing factories grew up as a result of the subsidy, but I don't really have any information to support that.
Okay. So let's talk, because you mentioned incentives, and I want to talk about incentives for a second. Obviously, the large-scale economy of America, largely reliant on trademarks and to do business. What incentives do we have in place that, besides our markets, and what you've described as enforcement seems to be weak, not necessarily your fault, but what we've done. What other incentives are out there for people to file fraudulent marks?
Well, with regard to China, my understanding is that the Central Committee in China sort of put out an edict. We want people to protect IP. And that then led the regional / local governments to do this. And so that is one incentive that's driving this. I mean, the Chinese government is so into this that now apparently the Chinese equivalent of the SAT, the Gaokao, now has IP questions on it. It's a college entrance exam. But in addition, you have to couple this with the rise of purchasing on the internet. So there are many legitimate companies that want to be part of this. That just want to sell on the internet to U.S. consumers. And so there is a legitimate business reason that Chinese citizens would want to file here. In addition, I'm told, this is anecdotal, that it's very prestigious in China to say that you have a U.S. trademark registration. But that's just anecdotal.
Well, so along that line, we've heard from companies like Target, which is the largest trademark filer in the U.S., that when the PTO allows fraudulent trademarks to be registered, those registrations block companies from legitimately using those trademarks. While big companies can afford to hire law firms to file applications for other marks, what's a small business with a limited budget supposed to do?
I'm sorry, I didn't catch the last part of it. What is a small business, what?
Supposed to do if they have a limited budget? They can't go around like Target can and just create a new mark.
Well, we are doing everything we can to stop the fake specimens from getting through. And we have to give people 6 months once something comes in to respond to us. So we're doing everything we can. We also have many staff working on outreach to small businesses, and they go around the country and help them understand what their rights are and what they need to do.
And so what's the remedy for a small business that is basically they're denied registration based on a mark that's falsely registered? What are they supposed to do?
They
what's the
could
remedy?
oppose it if it was in the opposition period, or they could seek cancellation at the Trademark Trial and Appeal Board.
And how long does that take, and what does that cost?
The filing fee, I think, is $400 US, and you could be pro se if you wanted to. One of the things that we're doing to remedy some of these problems is the U.S. Counsel rule. Are you familiar with that yet, sir? Yeah, so what we're trying to do is have all foreign domiciled applicants have a U.S. lawyer. And that way, there will be somebody acting as a filter and someone we can talk to and someone over whom we have jurisdiction to help us with this very important problem. In addition, we're auditing some of the registrations, and we started this a while back, and we found that over 50% of the time people were deleting goods they had just sworn were in use. So that's another one of our programs. It's very important.
Thank you.
Thank you, Mr. Chairman, and Commissioner Dennison, thank you very much for being here and testifying. Very important issue for my small businesses, growing businesses in my county, my state, my district, and of course for this country. It's interesting listening to the questions in your testimony and the issue of foreign filers, the issue of cancellation proceedings, and I think to myself, you got a small entrepreneur, sinks in their pension, a lot of work into coming up with trademark, brand protection, and all of a sudden they've got to go through a cancellation proceeding. Probably going to break their back. And now you're talking about foreigners, China, filing factories, China's policy of moving ahead and encouraging people in China to file. And yet I'm going to follow some of the questions that my colleague from Arizona had, which is the remedy. Now you're asking that they be represented by American attorneys. Win or lose, what's the remedy? Can you enforce a judgment? Can you enforce damages on a foreign-based firm beyond that attorney? I mean, as I close my eyes, think about an attorney, they have maybe errors and omissions insurance, but beyond that, how do you guarantee, how do you assure, what's the legal environment that we can come up with to protect Americans that have worked really hard to come up with these inventions, trademarks, and all of a sudden they have no protection?
Thank you for that question. Just for your information, in these non-use challenges at the DTAB, in the majority of the cases, there's a default. So you would file a paper and they would default, and that would be the end of it. So it would not, in most cases, be an expensive litigation. But we do not have the authority to award damages to anyone. That is not something that the USPTO trademark operation or PTAB has the ability to do.
Because I think what we have here is your agency, and you recognize the importance of free flow of commerce, trade, entrepreneurship, and you assume everybody comes in with good faith and is going to file this paperwork and is moving ahead. Yet we have a situation now that, for lack of a better term, we have a trade war going on. And maybe there's governments that are encouraging their firms and helping them. In China, it's very blurry to talk about government versus the private sector. I don't think there's a difference. You don't have that in the U.S. So I'm trying to figure out how we put our American firms on equal footing when it comes to these trade wars. You don't have a lot of authority. You're talking about putting together a special task force. Do you work with the FBI now? Do you work with Interpol, some of these other organizations? Do you have, lack of a better term here, databases where you can figure out, you got 3 credit cards that were the source of payment to a lot of these applications. You're investigating. We should have been doing this a long time ago. I'm not saying it's your fault. I'm saying that maybe our attitude, our predisposition to the new environment is not one that we're responding to fast enough.
Well, we are trying to do everything we can within our current power to help people.
And that's really the key, within your current power. So I would almost ask Mr. Chairman here, and I will ask him, can we come up with our own perspective on what powers you need to be an effective enforcer to protect U.S. free commerce within a open free market system where people have to have consequences when you abuse the system, whether it's criminal or other kinds of liability?
Thank you for that. We very much appreciate your support, and we have been brainstorming with the committee staff to talk about different options that you would like us to pursue. So, of course, we're happy to continue to cooperate and offer any kind of technical assistance we can to you on remedies.
And finally, Mr. Chairman, I'd like to offer this letter from Target for the record, and I also have some questions as well that I'd like to have answered. And seeing my time almost out, again, I just want to thank you, Commissioner, for being here, and look forward to working with you to protect American ingenuity, entrepreneurship, and job growth in this country. Thank you very much.
Thank you. We welcome your cooperation.
Without objection, so ordered. We will now hear 5 minutes of questions from the gentleman from Louisiana, Mr. Johnson.
Thank you, Mr. Chairman, and thank you, Commissioner, for being here today. I used to be a constitutional law attorney practicing in that area, and it's hard not to just remark on the brilliance of the founders' vision about all this. You know, when they gave us, Congress under Article 1, the ability to create laws to protect American intellectual property, and it's really because of that vision that we've been the extraordinary, exceptional nation that we are, in part because we take care of that creativity and ingenuity, and it's become part of the American identity. So your work's really important. We appreciate it. Of course, trademarks are a key national asset, and I know you're doing what you can to protect that in this brave new world that we're in. You've been asked some great questions. I want to follow up on a couple of those things. First line of questions about the local counsel rule. You were asked about the enforcement mechanisms, but for those back home who are watching, this is the proposal requires each foreign-based trademark filer to hire a U.S. attorney. The idea is the attempt is to ensure that future applications don't contain doctored evidence. But as you know, there's been some critics of this, and some people say, well, this is just the PTO just looking to other people, you know, to help solve the problem. How do you respond to that? Do you respond to the people who say, well, those resources, that time, that attention might be better used if they would just develop better tools and systems inside rather than sort of farming it out to other attorneys? What's the response to that?
We're not farming it out to anybody. What we're trying to do is trying to stop these people who come in appearing to be pro se, who are actually engaged in the unauthorized practice of law. And we believe that by bringing in a U.S. attorney, they'll be able to review filings, and they will ensure more likelihood of compliance with the law. So we feel very strongly that the U.S. Bar can help us. We're not dumping this on them. We're trying to ensure that this trademark system is as decluttered as possible and that people are actually complying with the laws and their ethical obligations, which is not the case right now.
So it's a bit ironic, but you know, there are some cases already, there's some articles we researched and read about how signatures of U.S. attorneys are being forged on these things, right? So now you need a whole new mechanism to try to prevent that. So what are you doing about that, or what's the plan there?
Well, the law is not in effect yet, first of all. It's not coming into effect till August 3rd. But we are keenly aware that the U.S. Counsel rule is not going to solve every problem, and we are aware that people could forge signatures. People who want to do bad things spend all day long thinking of new ways to be creative criminals. And so that's just, so we are certainly aware of that, and we are talking about that.
Apparently, there's already been some examples cited. I mean, I know it doesn't go into effect till August 3rd, but there's people preparing already to break the new rule. So here we go. Regarding the task forces, you've piqued our interest on that. Have you engaged, or has the task force engaged directly with private sector stakeholders, or to what extent have they done that so far?
No, it has not yet at this point. But it's internal to Trademarks right now. It has members who are IT gurus, and then we have trademark lawyers also working together. And so we have not engaged with the private sector yet.
I'm sure you would agree that if they're going forward, if there are more avenues for stakeholders to engage directly with your office, that we can have, I guess, better recommendations to meet the IP rights, the needs of the IP rights holders. So I hope that's in the plans. We would encourage that. I know you got a lot.
Certainly discuss that.
Yeah.
Thank you.
You mentioned earlier you're developing software to help catch bad actors. Has the task force explored using artificial intelligence or other real-time methods? If you covered that already.
Yes, that is under discussion.
Okay. And do you have a timeline for when your software that you mentioned will be finished and ready to be engaged with by the marketplace? Is it?
No, I do not have that because so far it is not ready. So it's hard for me to predict when the IT development would satisfactorily be concluded.
You mentioned you don't have jurisdiction over many of the bad actors. I know that's a great point of frustration, but do you think there are steps that Congress, that we ought to take to strengthen enforcement? I mean, I know that's kind of the spirit, the idea of this hearing, but if you had to boil it down to a couple of bullet points, what would you say?
Well, I would say that we enforce the laws that Congress has passed, and we are continuing to brainstorm with the staff to think about what would be the best approaches. Thank you.
Thank you. I'm out of time. I yield back.
Thank you. The gentleman yields back. We will next hear from the other gentleman from California, Mr. Liu, for 5 minutes.
Thank you, Mr. Chair, for holding this hearing, and thank you, Commissioner Dennison, for being here. I've always thought protecting intellectual property is one of the most important things that legislatures can do, because our economy, in part, relies on intellectual property. It's something that America can do well. And when I was in California State Legislature, one of the laws I passed allowed prosecutors to use the nuisance statutes to take down counterfeit goods, made it much easier to prosecute those kinds of cases. I am also now co-chair of the Tory Caucus in Congress, and we know that there has now been a significant rise in e-commerce. According to a recent survey, 79% of Americans have made a purchase online. We also know there's an increase in counterfeiting in e-commerce. So my first question to you is, what has your engagement been with e-commerce platforms, specifically around the fraudulent use of trademarks when it comes to toys?
Well, as you know, President Trump issued a memorandum on combating online counterfeiting and trademarks, and there is I believe it's DHS that is in charge of preparing a report, but the USPTO is heavily involved in developing that report, and that report is going to cover quite a few things. It's going to identify how online platforms are used to facilitate counterfeits, identify what those platforms are doing to minimize counterfeits, evaluate the effectiveness of the U.S. government and foreign government actions, recommend changes to data collection, and identify changes that could reduce trafficking. So I think that report is going to be very helpful, and that will be out, I believe, October 30th. So that's one of the things that we are doing right now on the counterfeit front. Another thing that we are doing on the counterfeit front is we have just engaged the National Crime Prevention Council, and we are going to do a multi-year nationwide campaign to educate consumers about what to look for. We think that it's really important for us to have an educated consumer base. In addition, we work with foreign governments on capacity building and technical guidance for foreign statutes.
Thank you. As you know, it's not just businesses that lose money from counterfeits from other countries. It's also a safety issue. A Tennessee family had their home burned down when there was a counterfeit hoverboard that they bought. So let me ask you right now, let's say you know that a particular hoverboard is fake, or it's a fake trademark, it's a counterfeit, what do you do? What's the process?
If we find that there is a fake specimen in the file, the examiner will refuse registration and request additional information. That's what we would do, is refuse the registration.
Let's say it's
would also-
already been registered,
Okay.
and then you realize later it's fraudulent or fake. Then what is the process?
The process is for a third party to file a cancellation proceeding at the Trademark Trial and Appeal Board.
And we've been given some evidence from various businesses in America that that proceeding can take quite a long time, and it's somewhat cumbersome. So how long would it take to get that fake item?
Well, as I mentioned a moment ago, there about, I think more than 50% of those cases go through to default, and so that will not take very long. It would just take a few months. If it were to go through the process, I would have to get you the statistics. I don't recall what the average is. I think it's more than a year, but honestly, I don't recall that figure.
Now, let's say someone registers a trademark and doesn't use it for, let's say, 2 years. Does anything happen? Or are they allowed to just keep it there forever?
Did you say 2 years?
2 years.
3 years is the golden standard. So after 3 years, someone could seek to cancel it and remove it from the register.
I see. But if no one moves, then to cancel it just sort of sits there.
That's correct. And then they're required to file a document between the 5th and 6th year after registration. And if they fail to file that, or if their filing is rejected, then it would be removed from the register.
Thank you. And then my last question to you is, are there any changes in the law that you think would make your life easier and make it easier to deal with counterfeits?
Well, again, we are brainstorming with your staff and would be happy to work with you on any technical assistance that we could provide.
Okay, thank you. I yield back.
Thank you. We will now hear from the gentleman from Virginia, Mr. Klein, for 5 minutes of questions.
Thank you, Mr. Chairman. Thank you, Ms. Dennison, for being here. I want to pick up on something that was just alluded to by Mr. Liu, the report between the 5th and 6th year filing, and how effective that is in light of the recent audits that you all have made permanent. And I think that can be an effective tool, but the audits are, as the audits are making clear, what you have are situations where people are complying in the 5th and 6th year, producing specimens, and then you have, for whatever reason, a very high percentage of the inability to verify use for at least some of the goods or services in the registration, upwards of 50%. Can you lead me through a timeline, because I'm relatively new? You began the 2-year pilot program in 2012, is that correct?
Correct.
Okay, so 2014, what happened to the program? Because I'm reading that it wasn't made permanent until 17. What happened between 14 and 17?
So we started the program with 500 post-registration documents that we pulled from 500 different files, randomly chosen. And those files all had to go through the process. So I'm not sure if it was 2014 or 2015 that they all went through the process. After that, we had to analyze the data. We also had to meet with stakeholders. And after we did all that, we decided to propose a rulemaking, so then we had to go through the rulemaking process. So as you know, the government can't always move as quickly as we might like. So that's what happened in terms of making it permanent. So we started November 1st of 2017 with the permanent program. And we started off with, I believe, 10 staff working on it, and we have recently increased that to 19. So that we can audit more registration. So we believe that going forward, we will have approximately 5,000 of the post-registration filings pulled each year. So we hope that that will be a deterrent. We are also considering whether to charge people what we'll call a zero fee if they delete prior to an audit or prior to the Trademark Trial and Appeal Board saying they aren't using something, and then charging them a fee for each item they have to delete if they're caught.
So November 1st of 17, 10 staff started. What did 2018 see 5,000 pulled?
No, we have probably pulled, I don't have an exact number for you. I believe it's in the range of 6,500 to date, but as I said, moving forward, it will be approximately 5,000 per year, because we have just recently doubled the staff a couple months ago.
That's great. The note I have says the results of the permanent audit programs have continued with approximately the same results. Do you have results from 18? Are you seeing just...
We're still over 50% of the people are deleting goods, so we do not know whether that is from ignorance. Some people, maybe it's sloppiness, maybe they're trying to cheat. It's really not clear. Some people have come to us and said, well, my client's really selling this, but they can't be bothered to go and find all the specimens. It's too much work. I don't know what the answer is, but it is a problem.
Sounds like the fee or the fine or whatever you're considering might be the appropriate response there. So thank you. That sounds like a good program, and I'm glad to hear you're increasing staff and increasing efforts in that area. Mr. Chairman, I yield back.
Thank you. This concludes the first panel of today's hearing. I want to thank Commissioner Dennison for participating in this hearing. We'll now take a short recess to set up our second panel of witnesses. The subcommittee will stand in recess for 5 minutes. The subcommittee will reconvene to hear testimony of our second panel. To follow up on the comments from the ranking member, Mr. Collins, I'd like to submit the fact that we received from eBay and Walmart statements that I would like to enter into the record without objection, and we appreciate their engagement with the subcommittee. And without objection, those comments will be submitted for the record. I will now introduce our second panel of witnesses. Professor Jeannie Fromer is a professor of law at New York University School of Law, where she specializes in intellectual property, including copyright, patent, trademark, trade secret, and design protection laws, and is a faculty co-director of the Engelberg Center on Innovation Law and Policy. She has written extensively in all fields of intellectual property law. Some of her recent and forthcoming scholarship studies trademark registrations empirically to examine whether we are running out of effective trademarks. Before joining NYU, Professor Fromer served as a law clerk for Justice David H. Souter of the U.S. Supreme Court and for Judge Robert D. Sack of the U.S. Court of Appeals for the Second Circuit. She also worked at Hale and Dorr, now Wilmer Hale, in the area of intellectual property law. Thank you for being here. Professor Fromer has degrees from Harvard Law School, Barnard College, and the Massachusetts Institute of Technology. Mr. Peter Brody is a partner at the law firm Ropes and Gray, LLP. He is an expert on intellectual property law and has been successfully litigating IP cases for more than 30 years. As a member and former chair of Ropes and Gray's Intellectual Property Litigation Group, Mr. Brody has wide-ranging experience with all types of IP cases: patent, copyright, trade secret, trademark, and false advertising. Mr. Brody writes extensively, including on intellectual property, and is an editorial advisor to Bloomberg BNA. Mr. Brody also serves as chair of the Legislation and Regulation Committee of the International Trademark Association. Mr. Brody holds degrees from Princeton University and Harvard Law School. Thank you for being here, sir. Joseph Camiso is the president of the Automotive Anti-Counterfeiting Council, A2C2, and brand protection manager at Toyota Motor North America, headquartered in Plano, Texas. In 2015, Mr. Camiso was instrumental in the formation of A2C2 and is a champion of the Council's mission to promote cooperation among automakers to eliminate the sale of counterfeit parts that can be dangerous to U.S. consumers and threaten public health and safety. In his current roles, Mr. Camiso has worked with Homeland Security investigations, U.S. Customs and Border Protection, and other law enforcement agencies to help stop the flow of counterfeit parts into the U.S. He has engaged online marketplaces to increase awareness of the risks of counterfeits, promote consumer safety, and enhance efforts to keep counterfeit parts, especially counterfeit airbag parts, off marketplaces entirely. Mr. Camiso earned his master's degree in business administration and management from California State University, Long Beach, and has nearly 25 years of automotive operations and supply chain experience. Welcome, sir. Mr. Robert Barchese is president of the International Anti-Counterfeiting Coalition, IACC, where he joined the leadership team in 2008. Mr. Barchese works with numerous organizations, both foreign and domestic, to stem the tide of counterfeit products that can harm consumers. He serves on the board of Europol's IP Crime Coordinated Coalition and on the editorial panel for the World Intellectual Property Organization. Before joining IACC, Mr. Barchese was in law enforcement, working in various capacities throughout the country. Mr. Barchese holds degrees from John Jay College of Criminal Justice and the University of Alabama. Thank you for being here, sir. And last but not least is Rebecca Mond, who is Vice President of Federal Government Affairs at the Toy Association, a not-for-profit trade association that represents businesses that design, produce, license, and deliver toys for children in the United States. In her capacity at the Toy Association, Ms. Mond has led on issues relating to counterfeit and unsafe toys entering the U.S. market. Ms. Mond has engaged with the federal government in numerous ways to ensure that toys are safe for children by reducing the sale of counterfeit and knockoff toys. Ms. Mond received a bachelor's degree in government from Georgetown University and a certificate in advanced product safety management from St. Louis University. Thank you for being here, Ms. Mond. We welcome all of our distinguished witnesses and thank them for participating in today's hearing. Before proceeding with testimony, you're hereby reminded that all of your testimony and written and oral statements made to the subcommittee in connection with this hearing are subject to penalties of perjury pursuant to 18 U.S.C. Section 1001, which may result upon conviction in the imposition of a fine or imprisonment of not more than up to 5 years or both. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. Professor Fromer, you may begin. And please cut on your microphone.
Sorry. Thank you for inviting me to be a witness today. I am Jeannie Fromer, professor of law at New York University School of Law, where I teach and publish on intellectual property. My remarks on trademark depletion and clutter draw on research with Professor Barton Beebe, also of NYU School of Law. Along with our written testimony, I have submitted our recent Harvard Law Review article, Are We Running Out of Trademarks? An empirical study of trademark depletion and congestion. Trademark depletion is the term we use in our article to describe the decreasing supply of unclaimed, competitively effective trademarks available to new market entrants. Although trademark law has operated on the assumption that there exists an inexhaustible supply of unclaimed trademarks, the empirical results we report confirm the opposite. It is becoming increasingly difficult for new businesses to find a trademark that is competitively effective, but that has not yet been claimed by another business. To give you a sense, now, nearly 3/4 of the time we speak, we are using a word that someone has already claimed as a trademark. Also, a majority of Americans carry a surname that is already claimed as a mark, meaning that they might have been born too late to claim their own name as a mark. Even using a conservative similarity matching protocol, nearly all the words we use on a daily basis and the surnames of a high proportion of American people are already registered or are confusingly similar to an already registered mark. Meanwhile, new applicants are increasingly shifting toward coined words and longer, more complex, and thus less effective marks. Yet even these efforts are increasingly failing. PTO refusal rates for confusing similarity to an already registered mark continue to rise. This problem is particularly acute for small businesses, which typically lack the sophistication and resources to find unclaimed, competitively effective marks and prosecute those marks to registration. Trademark depletion undermines trademark law's goal of promoting fair competition by raising entry barriers for new businesses with regard to finding and claiming unclaimed, competitively effective marks. Trademark depletion has been exacerbated in recent years by an inflow of applications originating from China. Media reports suggest that a significant number of these applications contain fraudulent statements of use and therefore fail to meet trademark law's use in commerce requirement. In fact, commercially available reverse image search technology reveals that some of these specimens of use being filed are clearly fraudulent, yet are not detected as such by the PTO. When these applications are allowed to proceed to registration, they contribute to clutter on the register. Clutter is the term trademark law uses to describe marks that are registered but are not actually used in commerce. It is important to declutter the trademark register both to abate rates of trademark depletion and to maintain the register's integrity. Doing so ensures that barriers to entry are not heightened in a way that protects incumbent businesses at the expense of new entrants and protects large businesses at the expense of smaller ones. To address the problems of trademark depletion and clutter, we support a mix of reforms to trademark law, including less costly processes than current possibilities for re-examination, cancellation, or opposition, which typically cost in the six figures, to clear the register of marks that are not being used in commerce, increased fees charged to non-small businesses to register, maintain, and renew their marks, and the institution of a lower standard for fraud on the PTO rather than the current heightened standard. Thank you, and I look forward to your questions.
Thank you. We will next hear from Mr. Brody, 5 minutes. Thank you.
Chairman Johnson, Ranking Member Roby, and members of the subcommittee, thank you for this opportunity to testify before you today. I'm Peter Brody, a partner in the law firm of Ropes & Gray in Washington, D.C., and an intellectual property litigator with a substantial focus on trademark cases. I'm also testifying today for the International Trademark Association, where I serve as chair of the U.S. Subcommittee of the Legislation and Regulation Committee. I'm pleased to be here this morning to discuss proposed legislation to amend the Lanham Act. This legislation would remove unwanted obstacles to obtaining injunctive relief in appropriate cases involving trademark counterfeiting, infringement, dilution, false advertising, and cybersquatting. As a number of the members of the subcommittee have observed in their comments this morning, trademarks are invaluable to the owners of businesses large and small. They enable businesses to develop a reputation and goodwill symbolized by their brand. But trademarks are also invaluable to consumers. We all use trademarks every day, as Congresswoman Roby mentioned, to make purchasing decisions, and we rely on them to lead us to products that we have come to know and prefer. But, as Congresswoman Roby also noted, our ability to rely on trademarks assumes that we can trust them to identify the same source and quality every time we place an order, or we reach for a box on a store shelf, or we stop at a chain restaurant for a quick meal. As the chairman suggested, the stakes in trademark cases are unique. The kind of harm that violations of the Lanham Act cause, harm to a business's reputation and goodwill, cannot be readily or effectively remedied with an award of monetary damages. In fact, courts very infrequently provide for such awards. The harm to consumers from trademark confusion also is not remedied by damages. Trademark harm must therefore be mitigated primarily by stopping the confusion at its source through an injunction. As many of you know, traditionally, injunctive relief is governed by a four-part standard. The plaintiff must show that it is either likely to succeed on the merits of its claim at the preliminary injunction stage or has prevailed at the permanent injunctive stage. The plaintiff must also show that it is likely to suffer irreparable harm absent an injunction. The plaintiff also must show that the balance of hardships tips in favor of issuance of the injunction rather than not issuance. And finally, the plaintiff must show that the public interest favors the issuance of an injunction. Recognizing the unique harms from trademark confusion, U.S. federal courts for decades virtually uniformly applied a rebuttable presumption of irreparable harm upon a finding of liability, that is, likelihood of confusion, at the preliminary injunction stage, or that a plaintiff was likely to be able to prove that liability. In other words, such findings led to a presumption rebuttable by the defendant that the irreparable harm prong of the traditional test for injunctive relief had been met. With this presumption, the plaintiff could obtain injunctive relief, assuming the other prongs of that test were also met. Recent developments in the law of Lanham Act remedies, however, have resulted in federal court rulings that hinder trademark owners' ability to obtain that injunctive relief. In particular, over the past decade, a number of federal appellate and trial courts have reversed course and discarded the longstanding presumption of irreparable harm, even when they have found a likelihood of confusion or, at the conclusion of the case, actual confusion. These courts base their decisions on a Supreme Court decision involving unrelated issues of patent infringement, not the Lanham Act. The analogy, however, is deeply flawed. Unlike the Lanham Act, the Patent Act provides for a guaranteed monetary remedy in the form of a reasonable royalty. And patent infringement does not cause the kind of unquantifiable harm to goodwill or reputation the Lanham Act is intended to address. Legislation reestablishing a presumption of irreparable harm under the Lanham Act will eliminate this unwarranted obstacle to injunctive relief. I want to highlight in my few seconds remaining that there are 3 key safeguards embedded in the proposed legislation to ensure its fairness and equity in application. First, the presumption only arises if the plaintiff has proven likelihood of confusion at the preliminary injunction stage or actual confusion at the conclusion of the case. Second, even if the presumption arises, it is still rebuttable. And finally, the proposal would not alter the remaining prongs of the test. The court would still have to find the balance of equities and the public interest favor the injunction. Mr. Chairman and members of the committee, thank you for this opportunity to express our views.
Thank you. Next, Mr. Camiso, you may begin. And I've just butchered that name, I'm sorry.
Thank you, Chairman Johnson,
Camiso,
Ranking Member Roby,
right.
and other members of the subcommittee. I appreciate the opportunity to speak before you today. I am Joseph Camiso, the frontline manager at Toyota, responsible for fighting counterfeit parts and the impact that they have on my company, our customers, and the public. To assist in this ongoing battle, I collaborate with my peers at 10 other U.S. automakers. Together, we make up the Automotive Anti-Counterfeiting Council, better known as A2C2, of which I currently serve as president. The threat of counterfeit auto parts is significant in many ways. First and foremost, they give rise to serious public health and safety concerns. They often fail to perform as intended, resulting in catastrophic failures with potentially fatal consequences. I have a short video that will illustrate this far better than I can. And now, with the chairman's indulgence, I'd like to share this video with the committee. This is a NHTSA video showing a catastrophic failure of an airbag, shrapnel in the passenger seat. This was a test buy off an e-commerce platform by my peer at Hyundai. They conducted the testing along with Homeland Security. This speaks to the tight specifications that genuine airbags are built to. In this case, the bag opens fractions of a second late. This again speaks to our specifications and how bags are supposed to unfold once detonated. It's a standard bench test that our wheels, genuine wheels, go through. Imitation wheel fails miserably. This shows our car's performance with counterfeit brake pads. And this is a bench test with counterfeit brake pads. After a few applications, pads actually ignite, potentially igniting the car as well. Unfortunately, counterfeit safety components like the airbags, wheels, and brake pads that you just saw are commonplace, as are counterfeit windshields, filters, engine components, and spark plugs. Simply put, almost every type of auto part can be and has been counterfeited. There are over 265 million vehicles in this country, and nearly every citizen either drives a car or is a passenger in one. Counterfeit auto parts are a threat to each of us. Of course, this problem has a significant financial impact as well. Using recent data from the Organization for Economic Cooperation and Development, the estimated financial impact of fake auto parts entering our country exceeds $1 billion, and that's just for A2C2 members. Much of this financial activity is fueled by online marketplaces. A2C2 members have reported tens of thousands of infringing and counterfeit listings to marketplaces. And for those listings removed, we don't know how many resulted in prior sales of fake parts to unsuspecting consumers or repair shops. As our friends in Homeland Security have said, A2C2 is a group of the committed, not the curious. To illustrate, since forming in 2015, we've trained almost 1,000 CBP officers. We've collaborated with Homeland Security on dozens of criminal and civil investigations, and we've enlisted the support of the IPEC office and the IPR Center to increase awareness. And we've engaged with multiple e-commerce platforms to prevent the sale of counterfeit auto parts. But moving forward, we remain concerned with the level of fake parts offered for sale through online marketplaces. We have several recommendations that we believe could help, including such things as increasing consumer awareness, having platforms proactively share information about bad actors with industry, law enforcement, and other stakeholders, and to notify buyers of counterfeit auto parts. Platforms can also work to increase seller and product vetting, and they can strengthen penalties for repeat offenders of health and safety products, such as auto parts. E-commerce marketplaces have effectively linked counterfeiters with unsuspecting consumers, and the burden of stopping these criminals should not fall disproportionately on the brands that they are victimizing. Ultimately, marketplaces should be held accountable for the product that they sell. Since our formation, A2C2 members have banded together as an industry to mitigate this growing threat to public health and safety. We are excited to participate in the creation of a framework that will enable real and scalable solutions, and we are pleased to support your efforts however we can. Thank you for the opportunity to testify today. I'll be happy to answer any questions the subcommittee may have.
Thank you. We will now hear 5 minutes testimony from Mr. Borghese.
Chairman Johnson, Ranking Member Roby, members of the subcommittee. Thank you for the opportunity to appear before you today and to share my thoughts and experience on this important topic. 40 years ago, a handful of companies came together to build a community in the fight against fakes, realizing that the trafficking of counterfeit goods was a problem too large for any of them to solve on their own. Today, the ICC's members span across industry sectors and include some of the world's most famous brands. And though we've grown considerably over the past 4 decades, our philosophy remains the same. We leverage the strength and the abilities of the IP community to do together that which we could not accomplish alone. We welcome the news of today's hearings and the much-needed attention that it brings to the trafficking of counterfeit goods in e-commerce. Without question, the growth of counterfeit sales in recent years has had a devastating effect on consumers, putting their health and safety at risk. Further, the loss to businesses cannot be measured in mere dollars and cents, but by lost jobs, reputation, and morale. Everyone benefits from a safe and trusted e-commerce marketplace, and the robust enforcement of IP rights online is an essential component to ensuring such a healthy marketplace. Unfortunately, robust is not always a word that we can use to describe the current level of enforcement. Too often, platforms' own policies serve as obstacles to the meaningful protection and enforcement of IP rights. Both my written testimony and the ICC's most recent submission to the U.S. Trade Representative for its annual Notorious Markets Review highlight the range of challenges that rights holders often face online. For the past decade, the ICC has addressed online trafficking by pursuing constructive engagement with a range of partners, including those in the payment sector, e-commerce platforms, registrars, registries, and the express shipping industry. Our guiding principle is to find practical solutions to intractable problems. Our follow-the-money approach to online enforcement that we developed in partnership with the credit card companies and money transfer companies have helped to choke off the flow of money to criminals anywhere in the world, online, and to thwart their business operations. Whether the consumer is in the U.S. and the seller is in China, we have worked with the credit card companies to close down merchant accounts around the world. Similarly, our partnership with the Alibaba Group, which we've had since 2012, significantly addressed rights holders' concerns with China's largest e-commerce platforms. In regard to that, I have 4 native-speaking Chinese folks working in my office, working together with a team in China from Alibaba, and we've seen significant progress since 2016 when we put that program together. Unfortunately, the challenges faced by business and consumers are not limited to foreign marketplaces. They're right here in our own backyard, too. That's why we've also engaged with a number of U.S. marketplaces and established a formal relationship with Amazon, which shows some promising results so far. Our engagement serves as proof of concept that when committed stakeholders share a common interest, we can make a real change. We've also encountered some, though, who disclaim accountability, viewing their legal obligations as a ceiling for what they're willing to do rather than a floor for what they're capable of doing. So while liability is an important piece of the puzzle, we must not forget that this is also about responsibility. All of us have a responsibility to use every tool at our disposal to fight this insidious problem. We at the ICC take that responsibility seriously. We see these folks that they have to be at the table. They're an integral part of the solution, and we found that when they're committed, they can make a tremendous difference. While we're pleased with the progress that we've had with our partners, there's more work to be done. This includes ongoing greater cooperation and investment of resources by willing partners. It requires new policies and creative strategies that adapt to the ever-changing tactics of the counterfeiters. And it will undoubtedly require the assistance, support, and encouragement of Congress and our law enforcement partners. As global commerce and e-commerce grow increasingly synonymous, we commend the subcommittee for shining a light on these issues. I thank you for the opportunity to address our members' concerns today and look forward to working with you to ensure that consumers and legitimate businesses are able to benefit from a safe and vibrant online marketplace. Thank you.
We will now have 5 minutes testimony from Mrs. Mond. 5 minutes.
On behalf of the Toy Association, thank you for the opportunity to testify before the subcommittee to share our concerns with counterfeit toys sold through e-commerce marketplaces. We appreciate your attention to this important matter. As background, the Toy Association represents more than 1,100 businesses, including toy manufacturers, importers, retailers, toy inventors, designers, and licensors, all involved in bringing safe, fun, and educational toys to market.
And if you could move that microphone over, yeah. Thank you.
The U.S. toy industry supports over 690,000 U.S. jobs. Approximately 3 billion toys are sold in the United States each year, totaling $27 billion at retail. Importantly, over 95% of U.S. toy companies are small businesses. Curbing the flow of counterfeit goods in e-commerce is an issue of critical importance to us due to the safety concerns of counterfeit toys. Consumers have come to rely on e-commerce platforms to provide discounted pricing and a wide selection of name brand quality toys also found at brick-and-mortar retail. However, under the current third-party marketplace system, illicit sellers with little or no accountability take advantage of this consumer faith by offering inferior and unsafe counterfeit toys that put our children at risk. Meanwhile, intermediaries are making substantial profit from these sales. Any business selling toys in the United States must be held to the same high safety standards that apply to toy brands and brick-and-mortar retailers that consumers have come to know and trust. By law, all toys sold in the United States must be compliant with mandatory product safety requirements, must be tested by an accredited independent testing facility, and must have certification. Legitimate toy companies spend significant resources to ensure the safety of their products. Suffice to say, counterfeit toy sellers do not submit to these safety and testing regulations. For these sellers, bypassing safety regulations is a competitive advantage to provide toys cheaper and quicker. Unfortunately, the counterfeit business on e-commerce is flourishing, and enforcement efforts and platform initiatives have thus far been insufficient to stop the flow of IP-infringing goods sold in the United States. Without significant changes to the existing framework, brands will continue to lose the war on fake toys. This hearing is timely with holiday season around the corner, during which around 50% of the toy industry's annual sales are conducted. When I asked one of our larger toy company members with a robust IP program for their overall thoughts of the state of play of counterfeits, their response was, "We're gearing up to be run over in the fall." The Toy Association has been working with e-commerce platforms and brand owners to improve communication and discuss our concerns. The Toy Association members, Amazon and Walmart, and non-member Alibaba have been directly engaged with our members in an effort to reduce the number of unsafe counterfeit toys on their marketplaces. In January of this year, the Toy Association released a paper, The Real Threat of Fake Toys, exploring the factors contributing to the rise of counterfeit goods sold through e-commerce platforms and some possible solutions. Specifically, the white paper looked at the following. First, e-commerce creates a low hurdle to sellers, giving illicit sellers near unfettered access to U.S. consumers. More must be done to ensure the legitimacy of sellers and to provide transparency into who is selling on the marketplaces. And more must be done to prevent identified illicit sellers that have been taken down from reappearing on marketplaces selling the same exact products. Increased and improved vetting of sellers prior to joining marketplaces, consistent data requirements across platforms, and improved information sharing would all be possible solutions to address this issue. Second, the burden of enforcement is disproportionately placed on the rights holders. Small businesses are at a significant disadvantage when it comes to tackling counterfeits. While platforms have established programs to help brands remove counterfeit listings, many of these programs are reactive and require constant vigilance and engagement of the brand owner with each individual platform. Moreover, some platforms offer added protections to more important brands, putting small businesses at a further disadvantage. We encourage Congress to explore whether marketplaces should have greater liability to ensure the authenticity and the safety of the products they sell. Without liability, the incentive for platforms to police their own marketplace is weak, as they are profiting from the sales of counterfeit goods with little to no risk. And third, consumer awareness is a critical component to reducing the prevalence of counterfeits, as consumers are largely unaware of the scope of the problem and are often unable to distinguish between known and illicit sellers on marketplaces. Some suggestions to solve this problem include increasing transparency into the identity of the seller and educating consumers on smart online shopping. We appreciate that platforms have been willing to engage with us on these concerns and have taken some meaningful steps in the positive direction. However, as it stands today, legitimate toy brands that sell in brick and mortar stores are playing by one set of rules, and foreign sellers that exploit marketplaces are playing by another set of rules or are not playing by rules at all. Without significant changes to level the playing field, we will be fighting a losing battle. Thank you again for your attention to this matter. I look forward to any questions you might have.
Thank you. We will now proceed under the 5-minute rule with questions, and I'll begin by recognizing myself for 5 minutes. Professor Fromer, do you think there are gaps in the current trademark law that will prevent the PTO from effectively addressing trademark cluttering?
Thank you. Yes, I do. I think that one of the challenges that currently face businesses that are trying to operate is the ability to cost-effectively remove unused marks from the register. The studies that are out there indicate that the average cost of a trademark opposition ranges from $150,000 to $500,000, whereas another one estimates the median cost to be $95,000, which means that many small businesses will throw up their hands and give up before actually challenging a mark that is not being used. In addition, as we heard in the previous panel, I think it would be helpful for the PTO to have more authority, take more initiative to audit crowded parts of the register to cull marks that are not being used.
Thank you. What are the impacts on consumers for trademark cluttering?
So consumers are thought to have the advantage from trademarks of having minimized cost. That is, that they can locate quality products more effectively through the shortcut of a mark without having to investigate that. The more crowded the trademark register is, the harder it is for consumers effectively to do that, because marks are closer together. There are many more marks they have to process, and they have to try to remember marks that are more cumbersome, longer, more complex. And so trademark law does not do its job of helping consumers in the way that it could without a less crowded register.
Thank you. Mr. Brody, as you stated, some courts that have discarded the rebuttable presumption of harm say that the Supreme Court's logic in eBay is not limited to patent cases, but that it applies to all types of cases involving injunctive relief. Why should trademarks be held to a different standard if the principles in eBay are applied across all types of cases and not just patent infringement cases?
Thank you, Mr. Chairman. Trademark harm, as members of the subcommittee have noted today, is a unique type of harm to businesses and also includes harm to consumers. This is a component that does not exist in patent law, and it is, as a result of the unique type of harm, very difficult to compensate trademark owners for infringement or dilution when it arises, and it also doesn't do anything for the consumer, even if the trademark owner is compensated for infringement. That's why embedded in the Lanham Act is strong injunctive relief and the availability of injunctive relief. The eBay case looked at a statutory structure in which there already was a guaranteed monetary compensatory relief for patent owners who proved infringement in the form of a reasonable royalty. There doesn't exist any such guarantee in the trademark law. And so what happens if money damages are far from guaranteed and are, in any event, an inadequate remedy, and courts are making it more difficult to obtain injunctions, trademark owners really have a situation where they have no effective relief available at all. It is an injury without an effective remedy, and that is what we are asking to be corrected.
All right, thank you. In the interest of time, I'm going to yield now for 5 minutes to the ranking member of the subcommittee, Ms. Roby.
Thank you, Mr. Chairman. For Mr. Camiso and Mr. Barchese and Ms. Mine, when looking at all of the online marketplaces, are there marketplaces that are more effective in combating counterfeits, and what best practices should market places employ to stop the sale of counterfeits, and are there specific actions or programs that are more effective marketplaces have in place that you believe have shown success in combating this issue? So if you just go down the line and share your thoughts, please. Microphone.
Thank you, Ranking Member Roby. All the marketplaces we deal with have programs in place. Some of those programs are more effective than others, and some are more aggressive than others. What we found is that most of them, if not all of them, require brand holders, rights holder participation. And to participate in each of those programs requires time and resources. It's very cumbersome, and we don't think that the solutions that are provided are scalable to the extent that they need to be.
Okay.
What we found is our initial program going back to 2010, working with the credit card companies to follow the money around the world and shut down merchant accounts, has been the most effective program. It's touted over in Europe and other places. And the reason I say that is the reason we have partnerships with Amazon, with Alibaba, is because we started to work with the credit card companies to impact the merchant accounts on those platforms. And then they came forward, and then we started programs with them. Just in regard to the specific platforms, we've had much success with Alibaba. We stood by them when they were the worst platform out there, and we've seen so much progress because, number one, I deal with the people from at the top of Alibaba. Number two, they've made substantial financial and resource investment to come up and be probably, one of the more progressive platforms.
Okay, thanks.
I echo the comments of previous two responses. Certainly, I think that one of the biggest challenges that our members have is that they have to engage with each individual platform, and that it's very resource intensive. And even if one platform clears up all the counterfeits, then all the counterfeits move to another one, or they move to the new platform. We're hearing about new issues that keep on popping up. So I think that one of the big issues with each of these programs is that they're reactive, that the counterfeits are already on the website. And so what we'd like to see all the platforms do is do more investment into a proactive approach to prevent the counterfeits and prevent the counterfeiters from being online and from staying online in a lot of cases.
Sure. Thank you. I appreciate that. Mr. Brody, in a court decision published earlier this month, the Third Circuit held that Amazon may be found liable for defective products sold by third-party vendors through its marketplace. In that case, Oberdorf v. Amazon, the court noted that even though a third-party vendor had listed for sale the defective product, Amazon could not look the other way and escape responsibility given its degree of involvement in marketplace transactions. What are your views on whether online platforms should be responsible for what they sell and distribute, just like physical marketplaces, and shouldn't the same reasoning apply regardless of whether the defective products at issue are physical items or digital goods?
Thank you, Congressman Roby. Under the Lanham Act, certainly resellers are equally liable for infringing marks or for counterfeiting. So there is a statutory basis for seeking relief against those parties. Whether they are typically the most effective target for enforcement efforts or not, I think depends a lot on the particular facts of the case.
Okay. Mr. Chairman, also in the interest of time, I'm going to ask this question, and then if everyone on the panel wants to submit an answer for the record, that probably would be best. But do you believe Congress should look at taking legislative action to combat counterfeits on online marketplaces? And if so, what changes in laws do you each think would be effective? And I would just appreciate it if you would each take that for the record and submit to this subcommittee for our consideration as we move through this very, very, very important issue. And Mr. Chairman, thank you so much for this hearing today, and look forward to continuing to work with you on this issue. Thank you all for being here.
Thank you. Next, 5 minutes of questions from the gentleman from Florida, Mr. Deutsch.
Thank you very much, and thanks to the witnesses. My apologies, I had to run to another meeting, but glad to be back to spend some time with all of you, and I appreciate your written testimony. And Mr. Barchesi, in your written testimony, you said counterfeiters will take advantage of any available means by which to get their products into consumers' hands. And so you recommend this multifaceted approach to when companies verify their sellers more robustly and data on known counterfeiters is shared between law enforcement and CBP and e-commerce sites, and then among e-commerce sites themselves. What do you do to incentivize e-commerce sites to adopt these anti-counterfeiting measures when sometimes it's just more profitable for them to ignore the counterfeiters altogether?
So thank you for that question. And as we speak, the Intellectual Property Center, that's also overseen by the Department of Homeland Security, is hosting a meeting today with my staff, with all the major platforms, with Amazon, with eBay, with the shippers. And we've been working on this project for quite some time. And what we're looking to do is basically collectively build out a database with 2 buckets in it. The first bucket would be private data sharing between the platforms so that they could keep bad actors out to begin with, which is the most difficult part. So they would share information so that a bad actor is not jumping from one platform to the other, like Rebecca had mentioned. The second one is the bad actors that have been confirmed, that information would be pushed over to Homeland Security, and then they would be able to do criminal investigations. So this is a project we've been working on now for several years. I think because of the intervention of the White House memo, it seems like they have much more incentive now to be there and invest in this, and we're very hopeful that this is going to take place in a reasonable amount of time.
And maybe it's premature and I should wait to ask until after the meeting, but with some of your suggestions, proof of identity, business organization documents, licensing agreements, have you seen a willingness from e-commerce sites to adopt any of these regulations, or is it an area where federal policy may be necessary to fill that gap?
I think federal policy is necessary for that because unfortunately, or fortunately, in China, they require national ID. So if you're selling on a Chinese platform, you have to provide national ID, whereas U.S. platforms, anyone could say they're anybody and sell on these platforms. I haven't seen any progress in that.
That's really helpful. Professor Frommer, I appreciate your focus on the dangers of having unused trademarks cluttering up the register. My understanding is that process for removing them is burdensome, especially for smaller businesses. Can you just talk me through the cost of challenging trademarks that appear to be fraudulent or at least ineligible for registration using the process that's in place, the opposition process at the Trademark Trial and Appeal Board?
Sure, thank you for the question. So the current two processes for challenging these fraudulent specimens of use are generally opposition and cancellation. Opposition, for the most part, has to happen within 30 days of publication of a trademark, so it's a limited window that third parties have to be vigilant for. If they miss that window, they won't be able to oppose. That's a limitation of opposition. Cancellation can happen on any grounds within 5 years of registration, but on much more limited grounds after 5 years, which is another limitation of cancellation, not to mention the cost that goes into this, which I think is a challenge for small businesses. It would really be helpful to have a ex parte possibility that is much lower cost in nature to challenge fraudulent or unused marks.
Great, terrific. I appreciate everyone being here. Appreciate those really helpful suggestions, and I yield back the balance of my time.
Thank you. Committee will next hear from Mr. Johnson for 5 minutes.
Thank you. If you're not familiar with our buzz signal, that's votes, so we're all going to talk real fast here for a few more minutes. I just want to just briefly note we've discussed Walmart here today, and in addition to putting the letter into the record, they have sent a top representative who's present, and we appreciate that, so thank you for being here. Mr. Camiso, I'm encouraged by the fact that the committee's chosen to take up this subject today, and in your written statement, you touch on the concept of further developing the nexus between marketplace sellers and consumers with law enforcement to catch bad actors. You were just discussing that a few moments ago. Could you elaborate briefly to the accountability model that you suggest in your statement, and do you believe there are voluntary steps that could be taken currently between marketplace stakeholders and law enforcement that would begin to curtail the problem?
Sure. Thank you, Congressman Johnson. There simply has to be higher penalties for sellers that are, in essence, criminals. And it can't be just to have them delisted and open up another account with another email address or another account name. There has to be something more substantial. At the other end of that, the platforms have this information, or should have this information, on the sellers that are selling these dangerous products. As I said, the penalty should not be just to remove the listing. The penalty should be to pursue prosecution. And the people who can do that, Homeland Security, with help from the stakeholders.
What amount of penalty do you think would be sufficient to be a deterrent? I mean, I guess it depends on the industry or who's involved at what level. I mean, how do we determine that? You got a suggestion? It bears a lot of thought, I guess, right?
I'm not prepared to answer that question. It has to be higher than what it is now.
Yeah.
We've seen cases where people selling counterfeit airbags have been given very light sentences. In some cases, probation. In other cases, very minimal jail time. In order to deter these criminals, the penalties should be higher.
Got it. Professor Frommer, does the PTO have the authority to remove a mark it should not have registered, or does the agency need additional statutory authority to remove fraudulent trademarks that it made a mistake with?
I think that the PTO needs to be given more statutory authority in this instance. There's a lot of power until registration happens. After that, power becomes much more limited. The only exception to that I know of is the recent permanent auditing program that's put in place, where the PTO has been able to get registrants not using their marks in whole or in part to delete parts of the registration. But it would be nicer to see that expanded more broadly, given how many unused marks seem to be on the register.
So if Congress gives the PTO more authority to remove fraudulent trademarks. What should we do to consider including, or what should we include in that legislation to ensure that the PTO is not going to misuse that authority to remove properly granted trademark registrations? I mean, there's a big distinction there, right?
Yeah, no, it's a wonderful question because, of course, this has to be balanced. And I think one of the things that has emerged today is that the PTO is looking forward and becoming better, which is great, at using technology, instructing examiners to deploy certain resources or lines of inquiry. But that's not backward looking at all, which means that things end up sitting on the register that if they had been applied for now might not have been. And I think it would be helpful to instruct the PTO to, at least in certain random audits or audits in crowded areas of registration, to deploy these new techniques as well in this backward-looking way to remove unused marks from the register.
Thank you. I got 50 seconds left. Wonder what Mr. Camiso, Barchese, or Ms. Mond how you would respond to this, or maybe all three of you could briefly. Should marketplaces share the identity of the seller of counterfeits with the company whose brand they're counterfeiting, with other marketplaces, with customers, law enforcement, et cetera? What do you think about that?
Yes, I believe so, to help us to pursue these criminals.
As I just mentioned earlier, we're working with all the platforms, the shippers, and Homeland Security to do just what you mentioned.
Good. You agree?
Absolutely.
And at what point should a marketplace remove a seller after the sale of one or two or three confirmed? I can kind of guess. You're going to say after the first strike, right? One strike, you're out, right?
One strike, you're out.
I think I agree. Would y'all agree as well?
That would be the ideal system. We understand some sort of leeway in that, but certainly not more than 3.
Thank
Gentleman's
you. I'm out of
time
time.
has expired. 5 minutes from Mr. Lou.
Thank you, Mr. Chair. Mr. Camiso, the video you showed of counterfeit auto parts was highly disturbing, and thank you for showing that video. I have a question about how do these parts get into the marketplace? So let's say you're driving and a warning light comes on saying something's wrong with your airbag. If you take it to a dealer, am I correct to assume that the chances of the new airbag being counterfeit would be low?
It would be 0.
It would be 0, okay. And is that because the dealer is using an OEM part, original equipment manufactured part, or is that a different thing?
Dealers get their OE parts directly from us, and we're confident in our supply chain.
Okay, so let's say you go to an auto repair shop that says, I'm also going to give you an OEM part. Is the chances of that being counterfeit higher?
I can't speak for independent repair facilities. They have multiple avenues from which they source their parts. They need to be cognizant of where they're getting them from.
Okay, and then if it's an aftermarket part, it doesn't pretend to be an OEM part, so that's not a counterfeit issue.
Not at all.
All right, so the counterfeiting is appearing at non-dealer places, am I right to assume that?
Correct.
Okay, thank you, that's helpful. Ms. Mon, a question for you about the safety of toys. So if it's a toy made by a U.S. company here, it has to meet a lot of different laws and regulations. So if you can't, for example, have lead paint in toys, correct?
That's correct. Regardless of where a toy is manufactured, if it's sold here in the United States, it needs to comply with those toy safety standards.
So let's say a toy with lead paint is being manufactured in a foreign country and then being sold on an e-commerce platform. A consumer would not know that, correct?
That is correct. And a lot of the safety requirements that apply to toys that are sold in brick and mortar stores are being completely skirted, and toy counterfeiters aren't complying with those requirements.
If a consumer were to buy a toy on an e-commerce platform, would they know where it's coming from? Do they have any idea?
No, not necessarily. In a lot of cases, a consumer might think that they're buying a legitimate toy, but they are, in fact, purchasing a toy from a third-party vendor that is not necessarily, they might be selling a counterfeit, or they might be selling an unsafe product.
All right, so let's say e-commerce platform is selling a hovercraft that is counterfeit, and they've been told it's counterfeit, they know it's counterfeit, and then a family buys it, house burns down. Is that e-commerce platform liable for knowingly selling an item that they knew was counterfeit?
Well, from what I understand, there's a recent court case that has changed the liability for third-party marketplaces, and so we're certainly encouraged that that conversation is shifting in that direction. But that said, in the past, the liability for marketplaces has been limited in instances where they are knowingly selling unsafe products.
Thank you. And if you could submit to this committee some ideas for making our laws better, that would be helpful.
Happy to do that.
Thank you. With that, I yield back.
I thank the gentleman. We shall now hear from Mr. Klein for 5 minutes.
Thank you, Mr. Chairman. Thank our witnesses for being here. Mr. Brody, can you talk about the challenge of quantifying the harm to reputation?
Precisely. That's the problem. The court's long recognized that consumer confusion is a type of harm that is especially difficult to quantify. And it's not surprising that when you look at the vast number of trademark decisions that have come down over the years, there aren't a high percentage of them that involve damages awards. Typically the relief, and I think the ranking member before you noted this, that the game was all about getting the injunction. And that's why the presumption was so important. Without that, proving harm typically involves having to prove diversion of sales and then tracing back those sales to someone who was actually confused. And that's a chain of causation that in a court case can be extremely challenging for the plaintiff.
Right. Well, I agree with you that in light of the Supreme Court's failure to act, it's time for us to act. So I appreciate your comments. Appreciate all the witnesses' comments. Mr. Chairman, I yield back.
And I want to thank each witness for your testimony today. All of your, without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And once again, thank you very much for your time and attention and your testimony today. With that, the hearing is adjourned.